I'm delighted to introduce Chris Hoofnagle. He's a lawyer, and he's the director of the Information Privacy Program and senior fellow for BCLK and the Samuelson Law, Technology, and Public Policy Clinic at the law school. And he is an expert on information policy, and he will lead you through issues of privacy and the Google book settlement.
Thank you, Anno. It's a pleasure to be here today. I can't think of an issue that is more appropriate for a school of information. We are thinking about a kind of library for the future. We are thinking about copyright policy, about technology policy, and this really is an excellent event and topic for you to focus on, Anno. So thank you for having this event. I also wanted to welcome you as a ambassador of citrus to our building, the Sudarcha Dai Hall. This wonderful facility was just opened earlier this year. Do take some time to check it out. We have a tech museum right next door where you can see some of our faculty's work here. We also have a 15,000-foot nano manufacturing lab and clean room. It's really cool. They won't let you in, but you can look through the windows and just imagine what our students will be doing here. So I want to get going here because we have an hour and a half to talk about a series of nuanced issues in the GBS settlement. But just by way of introduction, I've done a lot of work about how Google talks about privacy, and I think this is a theme that we'll be visiting here today. You frequently see Google representatives saying that privacy is important. In fact, I did a paper surveying hundreds of articles looking at how Google frames privacy issues, and their most frequent representation that appears in newspapers is privacy is important, or we think privacy is important, which is great. And we also see a lot of we've thought about these issues. We've thought about security. We've thought about privacy. And my main kind of message in this article is that journalists need to take them a little bit further on that. These are great general statements, but we're waiting for the details, and the details are actually what really matter. And then finally, we hear a lot from Google about privacy by design, but what we know from research here at Berkeley is that privacy by design requires early intervention. If you want to design privacy into a product, you have to do it at the inception. And so now's the time to talk about these issues. And we have a great panel to discuss these issues. I will briefly introduce them as they come up to speak. First, we have Angela Maycock, who is Assistant Director for the Office of Intellectual Freedom at the American Library Association. Angela, would you like to take it away?
I will. Thank you. Thanks for the introduction, Chris, and thanks especially to the organizers of this conference for inviting me to be here. I'm really thrilled to be a part of the discussion and really to learn from my fellow presenters as well as you in the audience. I think we've all seen that this is an extremely complex issue, and so there's a lot of conversation I think that needs to happen. The Google Book Search settlement presents some incredible opportunities, and I think in a lot of ways a glimpse of the future of library services. And as a result, we need to think really critically about some of those implications. And as Chris sort of alluded to, the settlement as it exists now is absolutely silent on user privacy. And that silence is in really stark contrast to the incredible detail that it takes with a number of other issues, things like the security of security protections for the digital books themselves. So I think we've thought a lot about privacy for inanimate objects, but not for actual people. And we've, as Chris also mentioned, we've received a lot of informal assurances about privacy protections, but that's really all we have to go on. And I think my big concern is that we seem to be seeing that there seems to be this strange paradigm where we say privacy is so important that it sort of gets dismissed. out of hand. It's so important to us, but it's such a complex issue that it hasn't been dealt with specifically yet. So I think it's a real concern. And my role here today on this panel is really to sort of try to provide a context and a framework for our discussion about privacy. So to that end, I'm going to be addressing some sort of core questions, and I'm going to start basically with, why do libraries and librarians care about privacy? What's our history of protecting user privacy? What are some major threats to reader privacy? How does a loss of privacy actually affect readers? And then I'm going to try to transition that discussion to what are the implications of that for digital distribution of books and the Google Book settlement in particular. I think from my perspective, certainly at the Office for Intellectual Freedom, at ALA, it's absolutely crucial that we start with our principles and then build out the discussion from there. So that's what I'm going to try to do. I want to start with a couple of definitions just to make sure we're all kind of on the same page here, particularly defining privacy. So in a library context, privacy is the right to engage in open inquiry without having the subject of your interest examined or scrutinized by others. That's what privacy means to us in libraries. Confidentiality is something that exists when a library is in possession of personally identifiable information about its users and keeps that information private on their behalf. So we're talking about kind of two different things here. And so, as comes up throughout this discussion, and I'm sure will come out throughout the day here, libraries and librarians have a really long-standing commitment to protecting user privacy rights, both the confidentiality of library records and the actual privacy of library use. So libraries provide access to information on all subjects from all points of view, and library patrons make individual choices about what information they're going to use. And so a lack of privacy in that kind of intellectual endeavor, especially when using a library, can have a significant chilling effect on an individual's exercise of their First Amendment rights. So librarians, as a result, really recognize that if library users are going to feel truly free to exercise their First Amendment rights and to make individual choices, then they have to have a reasonable expectation that their use of library resources is going to be kept confidential. So First Amendment right, and I should also mention when we're talking about sort of our fundamentals, that ALA's Code of Ethics, which is our ethical framework for our practice and our profession, has asserted a right and a protection of library records since 1939. So we have a really long-standing history here. First Amendment rights are considered chilled, and I will leave it to some of the more the legal folks in the room to talk more about this, because I'm a librarian. But they're considered chilled when people who are seeking to engage in activities that are protected by the First Amendment feel reluctant to do so because they fear the potential consequences of their actions. And when we think about that chilling effect, I think we really need to be focused on the potential societal loss and cultural implications of that. Libraries, as we all know, are cornerstones of democracy. They're a great equalizer. They're where the informed citizenry that's necessary for a democracy to function is possible. Libraries make that possible. So I think we need to think very carefully and look very carefully at that. I want to talk briefly about some challenges to reader privacy, and I don't do that to be alarmist. I think that, but I think it's important that we're all thinking about what past challenges to privacy in libraries have looked like, so that we can kind of extrapolate from there and think about what what future challenges might look like as well. I want to mention that the American Library Association and the Office for Intellectual Freedom, where I work, in particular, we provide guidance and support to libraries who are facing some of these kinds of challenges, and we do that on a confidential basis. So there are actually relatively few recorded cases that document particular challenges to attempts to obtain library or bookstore records, but I want to talk briefly about some of them and about what some of the implications are for those. And I do that also to sort of counter, I think, some attitudes or misconceptions that we often hear about, good people don't have anything to hide. I don't have anything to hide, or why would anyone even potentially be interested in my reading records? There's just nothing interesting there. And so I want to talk about a few specific examples where that was not the case. So in Wise County, Texas, the district attorney's office approached the Decatur Public Library, requesting the names, addresses, and telephone numbers of all individuals in that county who had checked out books on childbirth within the previous 9 months. The district attorney was actually investigating a child abandonment case. Unfortunately, it turned out that the police had no evidence indicating that the person who had abandoned the child might have borrowed library books on childbirth, and as a result, because the library presented a challenge to the subpoena, the court actually quashed the subpoena, so the records were not given up. Similarly, the Supreme Court of Colorado held that law enforcement officials could not justify a request for information about a consumer's purchase from the Tattered Cover bookstore. Many of you, I'm sure, are familiar with Tattered Cover in Denver and their strong commitment to the privacy rights of their readers. Oh my gosh, I'm running out of time. Okay, I want to actually wrap up. I didn't mean to take up this much time, but I think that what I want to get back to is that oh gosh, now I'm all off. I think that I want to come back to taking these core privacy principles and extending them into the online world and into the digital distribution of books. And I want to mention that the American Library Association, where I work, we have not opposed the settlement, the Google Book Search settlement. We filed comments with the court in advance of the original May 4th deadline, and what we asked for was vigorous oversight by the court. And we brought up issues, a number of issues, but reader privacy was really one of the core ones there. And I think that what we've seen from Google is they've been great listeners. Dan especially has attended a lot of our conferences. He's been on a lot of panels. He's heard, he's really gotten an earful from librarians, and we know that they're listening, and we hear that, and we see statements about the importance of privacy, but they're informal statements, and we need to make sure that those informal statements and assurances get actually codified into policy so that there's a way that we can make sure that there's accountability here as well. And with that, I'm going to turn it over to our next panelist. Thanks.
Thank you, Angela. So delighted to say that we have Tom Leonard, the university librarian here at University of California, next. And Tom, would you like to take it away? I apologize for the brief introductions. I want to get to the content today.
Well, I'm just glad to be on the panel that concerns human readers, since we spent the morning with the non-human readers, but I will get to the non-human readers in a little bit. I'd like to talk about privacy before the Google Book settlement, how it exists especially on this campus, and then privacy as we hope or fear after the Google Book settlement. First thing I want to say is that Angela doesn't wear medals for bravery, but she deserves them, I think, and it really is the case that the public libraries of this country are on the front line of privacy cases. Research libraries are not as numerous nor as exposed to raw feelings as the public libraries are. By any definition of a research library, there aren't too many of us, certainly fewer than 100. There are more public libraries in this country than there are McDonald's restaurants. The cultural norms of our users in these two kinds of libraries overlap, but the differences between them are important. A borrower from a public library is usually viewed as having an honest personal interest in the readings. There's a sense of authenticity about that choice. On the campus, this is not the case. The reader is far more often viewed as completing an assignment or a project. It's easier for the borrowers here. And you can see this if you visit our main circulation points. You'll see a scrum of borrowers in conversation at the checkout desk. 20-year-olds are asking them questions about where they live. They're headed home to put perhaps their choices on Library Thing or Delicious Library. There's a sense of making public what your reading choices are, I believe, far more than in public libraries. Certainly far more than in the Berkeley Public Library, where if you visit today, my guess is you will see a line of people standing as if they were directed by HIPAA regulations in a doctor's office, keeping their distance from the person ahead of them, not talking, or maybe if they are talking, voicing their fears that somehow the radio frequency tagging system in that library is being fed to the government and revealing their choices. That said, the core objective for research libraries is protecting the user's anonymity. We do not want anyone reading, listening, or watching the materials we have to be monitored without a very good reason and the user's clear understanding that this is being done. We lay this out in a policy on our webpage, and if you go to your favorite web browser and choose Berkeley Library Electronic Privacy, I believe you will get that as your top hit. And I want to point out that this is almost as long as the entire Google Privacy Center FAQ, covering all of their products. Our privacy policy concerning network information is almost 1,200 words. Compare that to the 800 words in the most recent post in July of FAQs on the Google Book Settlement privacy blog. We need to remind ourselves that the Gettysburg Address was less than half that length, but still size matters in some respects here. Readers do know that we keep a record of what they have borrowed and that this will not be read by anyone save our staff in making renewals or in telling them they better return the material. At Berkeley, we purge these records after the work is returned and the business reason for the record has gone away. We also purge our data concerning an IP address connected to a licensed database about 2 weeks after this use of networked information. This brief retention protects us against breach of contracts, basically people stealing databases, that publishers watch closely and require us to police. The purging that does not happen when you use rare materials in a special collection. By definition, materials that are to be used in a room where you will be watched. We keep these records because we want to check back if they go missing. Again, the business reason is all determining. We can make a good case that this is necessary to protect the integrity of our collections. Some of you will be familiar with the career of the Mr. Smiley, who was a frequent library user and who walked out of many prestigious libraries with rare maps from special collections. He was caught with the aid of the records that never went away that documented his use of these materials. We try to run a library here at Berkeley so that the Mr. Smileys of the world can't steal our stuff, but that we have absolutely no records of their reading taste in the general collection or online. That said, we are not, I hope, a bunch of smug rule followers. There are exceptions, there are hard cases. One might consider, for example, an exception to the ALA guidelines when it comes to members of the press who are exposing the sins of people in government who have abused civil liberties. After all, this tradition goes back to the leaking of correspondence by Benjamin Franklin himself before the Revolution. And I think a flat violation of the ALA policy is rewarded far and wide in the case of the Watergate investigation. You will recall that Woodward and Bernstein, in the book and in the movie, sat with the records of the books borrowed by a member of the White House staff in the Library of Congress, and that helped them track the evildoers. I say greatest reward, not only because so many librarians liked that book and recommended it, but because a research library paid $5 million to Woodward and Bernstein for the papers of their total investigation. Papers that now live at the Ransom Center in Texas, and the Ransom Center now keeps very careful track of its users. Other cases that we sometimes have to ponder, you might ask yourself if there was organized pillaging of Native American grave sites in a region of the United States, would we want there to be no records of the people who had been using the maps and other descriptions of what is now a current crime scene? It's an easy question if you think we got a good subpoena. It's a harder question if you thought we heard from simply a tribe that wanted to protect its cultural heritage. Another hard case. If a group abroad is using our digitized collection to throw individuals into a class of untouchables, and that actually has happened, because you can correlate the locations of families to unclean jobs and hence today discriminate against them and offering jobs and housing. Do I, as a university librarian, have any business telling you about that? Or should I keep quiet because I'm a literal reader of the ALA code? And finally, let me just say that if the library of the future at the university is to develop all sorts of neat techniques of helping you discover things, if we are to be a little bit more like Amazon or Netflix, then we might well want to collect data that was personal to you so we could show you more works that you might want to contact. And if there's a low barrier to your approval of that, we'll have much better databases. There may be a trade-off, surrendering some of your privacy for some greater command of the subject matter. So now we come to privacy after GBS. And I must say, I am hopeful that we will have a Google Book settlement approved. As we hope or as we may fear. Recently on the UC campuses, there was a letter from 21 faculty leaders that commented, first of all, thanking the libraries for what the faculty called exceptionally strong commitments to privacy, but also raising a number of concerns about the GBS matter. They pointed out that privacy is put at new potential risks, I think correctly. Where, they ask, is the Google commitment to privacy that is equivalent to what they could see in our libraries? Where is the commitment to match what Google now says about privacy on health information in that other Google service? They were concerned about monitoring the use of the library digital copy and some of the concerns that have been expressed this morning concerning the corpus. So let me put this in a campus context. And these are, I think, very, very cogent, very intelligent letter. We have the capacity right now to monitor searches at any of the 500 terminals on campus and also down to the level of the IP addresses for our remote users. But we don't do it. And if we did do it, we, I think, should lose our jobs. First of all, because you can see we violated our policy. And second, because we would have tied our people and our network in knots. as a practical matter, even with the latest software, the monitoring you rightly fear is wildly impractical. What is wildly impractical for us might be something that Google can manage, but I believe them when they say that this is not what they intend to do, or even believe that they could accomplish. I think I could say I believe Google, but that I would like to believe them more. I think that what we all need for our confidence is Google to move forward in articulating and finding new, if you will, narratives or genres to reassure us. I think that a plan for that reassurance and the issues they should address is before us on the web, courtesy quite recently of the Center for Democracy and Technology. If you go to your search engine and do CTD, privacy Google, you will see, I think, a nuanced, balanced appraisal of the direction Google should move in. We've heard it said that we don't need legalese, and I think that may be the case at this point, but we do need and should have more examples of how our freedoms could be protected. And some of these examples are actually given by Dan Clancy when he visits us, but it would be reassuring to see these posted and reviewed and studied. A concluding point. Google here at Berkeley reminds me often of the Berkeley alliance with British Petroleum, BP, a $500 million deal. And after the faculty had studied this, I think they drew two lessons. The first is, when you have the deepest pockets in the world, and when you can be sued by any and in any judicial system on the planet, you worry about saying too much. And the second thing I learned is that if you say too little, you will enjoy the reputation of BP. I look forward to Google proceeding on what I think is actually a good start in articulating its assurances to us. And I think I'll be followed by a colleague on the panel who will tell us something about the pitfalls and also the advantages that lay ahead for Google Book Settlement in drafting a better charter on privacy. Thank you.
Tom, thank you for those comments. Next, we have Jason Schultz. I'm happy to say that Jason is my new colleague at the Samuelson Clinic here at the School of Law. He's an experienced litigator, and I'm very proud to have him on our team.
Thanks, Chris. So I was thinking about kind of, in reference to a comment I made earlier about how to think about this situation. And how many of you are familiar with this story? There's been a story recently in magazines and on NPR and things about the Stanford Marshmallow experiment. Raise your hand if you've heard about this. Okay, well, it's this experiment. I'm actually not that familiar, but I sort of gleaned from the press that they did, I think in the 60s, where they'd take 4-year-old kids, maybe around there, and they'd put a marshmallow in front of them. And the researchers, all research experiment, would say, okay, I'm going to go run some errands. I'll be back in about 20 minutes. If you eat the marshmallow, that's it. But if the marshmallow is still there and you haven't touched it, I'll give you a second one. And I was thinking about that because it's all in the context of, can we predict what's going to happen in the future? How do we predict? Do we take what's in front of us now? Or do we wait? And, and how good are we at waiting? And these kinds of things. And what's interesting is that there you kind of have, at least, you're maybe a 4-year-old kid, but at least you sort of, in theory, know marshmallows are good, right? And you can have one or you can have two, but you're trying to guess how good that second one's going to be, right? But here, I think one of the contexts for this, which makes it really challenging, honestly challenging, is that we have a settlement before us and we're trying to figure out, is this a marshmallow, right? How good is it going to be? And then there's this sort of potential for something else, maybe down the road. We don't know if it's going to be 20 minutes. We don't know if it's going to be a marshmallow. Maybe it'll be burnt. Maybe it'll be stale. Maybe it'll be the biggest marshmallow we've ever seen. We don't know. And so I just wanted to kind of contextualize some of these comments throughout the day for us to think about, because it is a tough question. And I have to say that I'm torn often between taking the marshmallow and waiting. So I'll just say that as a sort of introduction. So I want to also give a sort of context as well to kind of how I ended up thinking about privacy in relation to Google Book Search, because by training and sort of the work that I've done previously, it's been mostly focused on intellectual property. And when Google Book Search sort of first came on the scene, this was all about copyright and fair use, right? So Google came up with what I thought was a very clever strategy for avoiding some of the more overbearing draconian copyright restrictions and getting at what was really, I thought, a very valuable way of accessing information from books. And I have to say I'm a big fan of the sort of, scanning in order to extract information that's valuable without allowing copyright to inhibit that kind of innovation. They put forward a fair use argument that said, look, we're transforming the information from within the book, and the only way to get it is to scan and index. And then we're going to show these little snippets for the ones that are in copyright that we don't have permission for. But it doesn't substitute for reading or buying the book, right? So we're not trying to cut out your market for buying books. We're just trying to help it's about information access, information location. And this is an argument that Google has made many times about all kinds of things, web search, image search, and I'm a big fan of it. I'm actually a huge supporter, and I think it's the right balance in copyright law. It's also, in particular, a way of addressing what many of you might be familiar with as the orphan works problem. That there are, in fact, a lot of copyrighted works out there where it's incredibly difficult, even if you have the money, the time, and the attention and the people power, to negotiate rights, right? So it's also like, well, maybe we'll give people at least some access to some information contained within these works, even if we're unable to find the copyright owner or get them to talk to us or things like that. But now we're kind of in a sort of different situation. So this is how privacy came up, which is that we have this settlement. And the settlement deals with so much more than just copyright and fair use, right? So when it first came out, it's a huge document. It took a lot of time to think about. And so I wanted to focus on four main concerns that have sort of emerged around privacy. And let me just say also that I'm not here to endorse or deride the settlement directly. I actually really enjoy the debate. I've been part of several, and I wanted to say that Google has been very active and engaging on the debate. Not only Dan, but some of their policy people as well. And so this is all in an honest, good faith spirit of trying to kind of tease out these issues, because I think they're kind of big. And like I said, we don't know whether we're going to get a marshmallow or not. So there's sort of four things that I want to throw out there for you to consider around privacy. One is the size of this deal. This is what makes it feel different than to me in some respects. By my assessment, I think this is the largest copyright licensing deal in United States history. Right? The range of works, the range of owner interests, I think that you could argue that this is the biggest thing we've ever seen. So that sort of on one level, just as a single point, makes me sort of wake up and go, okay, there's a lot going on here. Two is the compulsory nature of the settlement, right? And I think there are honest arguments on both sides about this, but it is a class action that includes, as members of the class, anyone who has a copyright interest in any book that's been published in the US between the time periods that they're talking about. So it has to be in copyright and it's up to a certain date. But it's pretty big, and if the settlement goes through, if this judge does approve it, it is binding on everyone unless you opt out, right? And I'll talk about opt out in a second. But the reality is very few people ever opt out of class action. So you may not have ever even heard of this, right? They try and give notice, but even if you've never heard of it, you could be bound if you have a copyright interest. And so it's got a pretty big reach, right? So it's something that concerns us that we've got to think about. Now, maybe it's the right solution, but it's still pretty compulsory and pretty big. And so one of the things when you look at privacy in relation to this is not like any other Google product. In fact, it's not like many products that we deal with, right? So I'm concerned about privacy with the Amazon Kindle. I'm concerned about privacy with my very own iPhone, right? Apple knows a lot about me that I might wish they didn't, and they have a privacy policy, and I'm like, well, and I'm a lawyer, and I read these things, and I specialize in these things, and I'm not even sure exactly what I'm in for, right? So there are concerns that expand beyond Google to other products. But what's interesting and sort of different here to me is that the nature of this class action settlement is that it is going to take all these copyright owners and anyone who has an interest in copyright in a US under copyright book that doesn't already sign up with Google, and it says you're part of a deal. And the deal is you are giving Google permission. You are granting them a copyright license to do this thing. And in return, and this is what the settlement says, you get all these benefits. And so what that raises is this question of, well, shouldn't one of those benefits be privacy? In other words, Google can kind of offer its products now to you, right? web search or Gmail, whatever, and it's kind of take it or leave it on an individual user basis because they don't quite need permission from anyone to do it, right? They can offer Gmail, and they don't necessarily need to get a copyright license to do it. In fact, I don't think they do, and they don't really need permission from almost anyone. But here they need permission, and they need permission from a lot of folks. In fact, probably more folks than anyone's ever needed permission from before to do this. And a lot of those folks are you people in the room and anyone who has a copyright interest, authors, publishers, right? So this is the question. This is why it's different. Should we give Google permission? Is this the right deal, right? And do we want privacy to be part of the deal or not, right? Are there certain authors and publishers and those of us who believe that privacy is important enough that it should be in the deal, Google should be bound, locked in order to get these permissions? So that's sort of concern number 2 is the compulsory nature and then how that affects us vis-a-vis some other product. Third is the implications for privacy. And that is that if you start to involve something this big, with this many people and with this many books, and as we've heard already talked about, I think you do run up to a question of how much privacy are we talking about. If Google and others potentially can look at every page of every book that you read through the service, it raises serious, serious broad concerns. And I'll say that Google has made a lot of assurances, and we can talk about that. And the fourth is, and this is sort of from my legal scholar perspective, is that through this class action mechanism, Google is trying to do a sort of, use the legal system to address a number of problems it has, particularly the orphan works problem. And one might consider it a sort of legal hack. And let me say that I'm a big fan of legal hacks. I used to work at the Electronic Frontier Foundation, EFF, which I think we're very proud of legal hacks when there's a problem that needs to be solved. They're not a bad thing. In fact, they're often a good thing. But I think this is a mechanism for which class actions have been rarely used, and I think we do need to assess that. Now, I want to focus just for a bit on the government access issue. And the government access issue is the one in particular here that I think comes out when I look at this privacy, in that governments are really interested in law enforcement, in particular, very interested in getting information about people that they're suspicious of. And as we've heard, they will often come to libraries and bookstores. And so it begs this question of sort of, as we think about it, is Google going to be better or worse at this? And one of the key things that we've heard both from the previous speakers is that there's sort of an assessment that goes along, right, from the people who control the data. Do they turn it over or not? But what comes out in the court cases is that often if they stand up and fight, it ends up going to a judge. And often judges, and Tom actually talked about hard situations, judges can make often decisions about hard situations that are transparent, there's usually a published opinion, are reviewable, and contestable, right? So there's a sort of accountability mechanism that goes into that. Also, culturally, if you see, or other various libraries decide to turn over information, let's say they say, we're going to show everybody what Jason Schultz reads. He reads all the Harry Potter books, isn't that funny, right? Or he reads stuff about drugs, or about, sexual violence, or about HIV, right? Which could be more controversial. In some sense, culturally and institutionally, there are accountability mechanisms. And I think we have to question, are the accountability and enforcement mechanisms with Google sufficient enough? So I want to end just on a sort of question about, so I want to end actually by pointing out 2 models that Google has that we should think about that it has committed to in other realms, and one of them has been referenced. In Google Health, for instance, Google has made a commitment that all of the records in Google Health will be kept separate from all your other Google services, right? So if you use Google Health, and there's a question of how that plays out in your life and your privacy, at least you know that it won't be mixed. It's sort of siloed off. They have not made that commitment here for Google Books, right? So that's one thing to think about. Should they make that commitment? And if so, how binding should it be? The other is that Google's location product, which I think is called Latitude, has a kind of amnesia built into it. And that is that it only remembers the last location you were. At least this is what they say. This is sort of their approach. So that as you update your location, it doesn't remember where you were in the past. It sort of is only like, I'm here right now. And one wonders if this also could be applied in some sense to books. In the same sense of that if they do keep information, it's minimized both in terms of amount and time. So I want to kind of end on that and just say that I think these are important questions. And the question is, what does Google need to do to reassure us of this? And how, if Google doesn't follow these norms and doesn't respect privacy, how will we know? And how will they be held accountable? And I think those are good and open questions to consider. Thank you.
So thank you, Jason, for that excellent summary. We are here in Berkeley, so we have to consider the fact that the second marshmallow might be organic. It's an option you didn't mention. That test has always been done. That test has also been done with Oreo cookies. And there was one kid who opened up the cookie, licked it, and then put it back together and put it down on the table. So, there's 3 options. A genius kid. I'd like to find that kid today and hire him. Our last panelist, before we turn it over to questions, is Michael Zimmer. And Michael Zimmer recently completed his PhD at NYU, where he studied under Helen Nissenbaum and other shining stars in the area of new media. And it really is a pleasure to have you today. He's now a new professor at University of Wisconsin at Milwaukee.
Thank you. Thank you, Chris, and everyone for putting on this panel and inviting me to be here. And of course, in Milwaukee, that marshmallow would be deep fried and served on a stick. And probably was just at our state fair over the past week. Excellent. So for those of you that are not familiar with my work, I try to sort of look at the intersection of ethics and technology, looking at issues of privacy, intellectual freedom, access to knowledge. I try to wear multiple hats in my work. I'm a scholar, but I also end up being an advocate when it comes to privacy matters. It's hard to avoid that when you're also a scholar. That allows me to be a little bit more aggressive at some of the things I say than what I can say in my little ivory tower in Milwaukee. But I also try to be pragmatic about it and try to partner with the companies that I tend to criticize. So I try to work with folks like Google to come up with actual design solutions to the problems that we're trying to address today. And then my talk this afternoon, I'm going to talk a little bit more on the sort of the advocate role and be a little bit more aggressive in the approach. And I'm burdened with following 3 great speakers that really have highlighted all the key issues. So I'm going to try to sort of summarize that and still get us to lunch on time in the next few minutes. I've written extensively on the concerns with intellectual privacy as more and more of our information-seeking activities sort of converge in online forums, and especially with single providers that provide some amazing tools, companies like Google. And there are some serious concerns that we have from a privacy perspective. Search, of course, and Google becomes sort of our center of gravity for information-seeking activities. More and more people are sort of signing in to Planet Google to use their tools and gain information. And it's great, and you'll see that I did pretty much all my presentation using Google and relying on Google in order to make those kind of things happen. But the concern that we have, and that everyone in this room has already studied and been aware of, is what happens when our information-seeking activities sort of get put under the microscope. Inherent within the way that we're seeking information on the web, there's a large-scale infrastructure of data valence to monitor, to track what we're doing, often for very good purposes, but that infrastructure is there. And that's the kind of thing that concerns me as a scholar and as an advocate. To make a long story short, infrastructures of data valence constructed by search engines threaten the kind of intellectual privacy, intellectual freedoms that Angela was talking about. They might constrain our ability to navigate, to explore, to seek new ideas, to grow as individuals, limiting our privacy and our freedoms. So there you have 3 years of a dissertation in 30 seconds. And you have to be able to do that to move on to the next thing. But these are the kind of problems. This is why we were worried about the AOL search release a few years ago. This is why we're worried about data retention policies and how long are search engines keeping records? How long did the cookies remain on your machine? This is why we're concerned about issues about whether or not an IP address is potentially personally identifiable or not. These are all the kind of things that we push companies like Google to do better. And we applaud them when they do things like with health and latitude, but we also try to get them to be more transparent and engage in what I would describe as more ethically driven design decisions. So what does this have to do with the book search settlement? Speakers before me have pretty much summed it up, so it's hard for me to improve on their comments. But I do want to focus on two key issues that at least jump out to me when we start thinking about the potential service that this settlement might bring to us. The first has to do with sort of the norms of information flow that we have. And both Angela and Tom have already alluded to this, that when you walk into a library, there are certain expectations you have as a patron. There are professional norms that have been established, strong code of ethics, all the things that have already been talked about. That Berkeley does. I've worked with New York Public. They do the same thing. When you return a book, they destroy the record. The whole New York Public Library system does that. And that's a great thing for you as a patron to know that you have that kind of privacy protection. So those are the norms that exist within that context. So the concern is what happens when we move that context into more of a digital web-based realm. Do those norms come with us? When we think about searching on the web and what Google has provided to us with various web-seeking services, there are some differences between that and the library. Web searching sort of developed on its own. It has its own set of practices and principles and technologies. And there's a certain amount of tracking that's just inherent to web searching. It's the way it works. It's the way it was built, and we benefit from it. And Google's explained it to us in terms of how they track IP addresses and how your search terms show up in the URL, all those kind of things. That's part of the system. That's part of web searching. A lot of people just accept that, recognize that, yes, my searches are going to be tracked, and we move on. I don't think that's necessarily the right position, but that's a different debate that we can have. But that's what we think about web search. And my concern is that when we talk about Google and the libraries, which norms, which set of practices are we going to carry with us? Is it going to be the norms of the library or the norms of web searching that follow us when we start now accessing digital books in a library setting? Because remember, I'm walking into a library, sitting down at a terminal and looking at a book. So am I expecting the norms and the ethics of the library to come with me, or the norms and the ethics of traditional web searching and the other kind of products that Google has brought to us? So that's a key issue for me. Which way are we going to go? Is this service going to be an extension of the library or an extension of web searching? And I think there's serious implications on which way that we resolve that question. Secondly, there's a little concern about competition. And I think those will probably come up in perhaps later discussions. And I'm not an antitrust expert. That's why I married a lawyer who is. But there are concerns about, is there going to be competition if this settlement goes forward? We've seen evidence in the web search realm that competition actually had some positive impact when it comes to privacy practices. Just in the past year or so, there was this, remember all these headlines where Yahoo's dropping their retention to 13 months, Microsoft drops theirs to 18 months. There was sort of this battle in the marketplace about privacy policies. It wasn't perfect, and more could be done, but we saw some results of that if I didn't like Google's privacy, I could go to Ask and turn on Ask Eraser, and they supposedly erase all my data from their servers. So I had some choice on that. And the concern is that with the Google Books settlement, we may not have that kind of competitive pressure to build or improve privacy practices. So that's a concern for me. A second concern that I have about this, if we don't have competitive pressure to improve privacy practices, will there be any improvements other than just us advocates shouting on the rooftops every chance we get? So how am I on time? Okay. So where do we go from here? This is where I turn on sort of my pragmatic partnership mode. How can we develop new products? How can we sort of try to resolve some of these problems? We can look to Google. They've responded to some of these concerns. As I already alluded to, there's a FAQ and a blog post that was put up earlier this summer addressing some of these issues as they arose. So we can look to this for guidance. Google mentioned that a Google account would not be necessary for most of your activities on Google Books. It depends on how much of a book you want to look at. They've promised they're not going to sell the data that they might collect about you. And these are all good things. They've mentioned that their general privacy policy will apply, and that's a good thing as well. But we're being asked to trust Google, and I do want to trust, and I like to trust, and like Tom says, I just want to trust more. And if we start looking at some of the language and we start sort of teasing some of it out, when I put my advocate's hat on, I start getting a little bit nervous about these general statements that are being made, and without, like Jason's saying, we need to have a little bit more hardcore commitment to some of these principles in writing. One of the things within the blog post talked about how we want to always give users clear information about their privacy. And we do have that, but when I think about the battle that we had to add a 7-letter hyperlink on the homepage of Google to their privacy policy, it took a whole lot of arm twisting to convince people within the organization to get over the aesthetic burden that little privacy hyperlink has on the homepage. So these promises to give clear information, it's like, yeah, I know, but let's be a little bit better at this. And these are the kind of stories that, when you're an advocate, creeps back into your head about these kind of epic struggles we have to add a link as simple as that. There's also a lot about thinking hard about privacy, and Chris mentioned this in his introduction. And I know Google's full of a lot of really smart people that think really hard about these kind of problems. But the concern is, what kind of thinking, what perspective, what approaches are being done in this kind of thinking. And the example I want to bring up is Street View. I know Google thought really hard about Street View. I've talked to the people that were on it, the product councils that were on this team when this was being developed, and they were very concerned about privacy and these kind of issues. But when they sat down at the end of the day, certain statements were being made by some of their privacy people and some of their councils about the concerns that we have with Street View, the kind of concerns that I brought up when Street View was released. They mentioned that the imagery we're taking is not anything different than what you can see on the street. We're just putting it, making it more accessible. It's the classic, it's already out there in public, so what we're doing is no big deal kind of argument. There's also statements being made that the U.S. has a long tradition of saying that it's legal and appropriate to take pictures in public and publish them. And this is what justifies newspapers publishing photos that a photojournalist just takes walking down the street. So this is a very legal approach to these privacy concerns. A lot of really hard thinking by legally minded people, realizing that we have precedent, that it's okay for us to do it. So we released Street View with very minimal privacy protections when it first came out. And this is the famous picture of Kevin Bankston of the EFF, walking down the street near his offices. You can identify him there and see him. We compare that to when Google was contemplating releasing Street View in Europe or Canada. Much stricter privacy regulations on the use of someone's likeness without their permission. Google had their policy people think about this. I've been in the room when they talked about how proud they were because they looked at the law and they realized they had to release Street View with blurred faces in those different jurisdictions. So again, this is an example where we have very hard thinking, but it was very legal thinking. And if you had an ethicist sitting in the room, you may have realized that, well, perhaps we should be blurring faces of everyone everywhere on the planet. Or perhaps it just isn't a good idea in the first place. And this is just my concern. When we talk about hard thinking, it's very important to me who is doing that thinking. I call again for Google to have ethicists as part of these processes. If we have product councils in each team, we should have a product ethicist on each team. I also know that's very hard to do. It's hard to bring ethics into the design room. I've worked on projects to try to do that in other contexts. I've written about how difficult that is to do it, but this is a company that's really good at tackling difficult problems, and I really urge them to, when they're talking about hard thinking, to sort of broaden who is doing that thinking and what kind of thought is going on in those design rooms. Quickly, I want to just close with a couple of design options. Google promises us, and I want to trust them more, that when they do build these products, that they will uphold the standards set long ago by booksellers and by libraries. And I really do believe that's what they're going to do and what they're going to strive to do. So what are some options that we have for them? Build-in anonymity. We've already had some examples of that on the panel. Is there a way for us to do this where we're not tracking IPs, where we don't require a Google account login? Can I have a login just for books that's not tied to my Gmail account and everything else I do on Google? Is there a way for them to do that? They can think hard and come up with ways to integrate anonymity into the product. Just like what Jason said, Google Health is a great example. We're looking at a specific domain of personal information as particularly sensitive, so they take different steps to try to protect that. They use SSL encryption. It's for the data flows, the data is encrypted on their servers, so on and so forth. So let's consider that your book searching data has the same kind of specific needs to be protected, just like your health data is. And once we get in that direction, then I'm going to stand up and say, well, we've got to do that about everything. And part of me thinks that's why Google might not be putting as strong of a foot forward publicly right now, saying that we do need to protect this book search data. Because I'm going to argue that, well, the data I search for in a book ain't that different than what I'm searching for just on a general Google search. And so all my intellectual activities, in my opinion, deserve that same kind of protection. And that's going to be where I'm going to be pushing them forward as we move down this process. My final point is then a call out to any coders or hackers we have in the room to help me give a little bit of power back into the user's hands. Has anyone heard of Track Me Not or have it installed on their machines? A handful of people. So Helen Issenbaum and Daniel Howe, a computer science PhD student at NYU, we developed this Firefox extension that works in the background and sends ghost queries to all the search engines while you browse online. It's not giving you privacy, it's not giving you anonymity, but it's sort of polluting your data cloud that Google's collected. You know, they could probably crack the code and figure out how we're doing it. Then we have different ways of randomizing and bursting and trying to make sure that, you know, bombing the White House is not one of the random queries that you send to Google. But you never know, right? But it's a way to sort of monkey with the system, right? And a lot of people, I'm sorry?
You have an ethicist.
Yeah. Person number 2 is our ethicist. So it's a tool to give some power back to the user, just to sort of say, and it's brought some attention and criticism and whatnot, but perhaps we need a Track Me Not for Google Books. That if I'm going to be sitting there and searching for books, maybe I should have a whole bunch of fake queries going on in the background. So it just gets a little bit harder to figure out exactly what I was really looking for when I did that. And it's not obviously a perfect solution for what we're doing, but it's a way that as an advocate or a hacker, you can sort of push back a little bit on some of the concerns that we have here today. So you can go and you can download this for your general web search and flood AOL and MicroWho and Google with some fake queries. My final statement, you know, sharing my co-panelists is that I am hopeful. Pam Samuelson wrote recently about the audacity of this settlement, and I have audacity, like our president, to be hopeful that this product is going to be extremely valuable for providing access to knowledge. And I'm really excited about that potential. But given these concerns that we've expressed on this panel, I'm also hopeful that we're going to be able to work these things out, that Google does want to do the things that they're saying, and that we just need to work and think really hard and harder to get this to happen in the way that we're looking for, from a very ethically driven way. And I'll end there, and I look forward to our discussion. Thank you.
Thank you, Michael. And I think, you know, we could go straight to audience questions since we've continued on for this time here. There are microphones circulating around. If you raise your hand. If no one has a question, I'll start with one. There's a question over here, and there's one here too. Thank you.
Hi, I'm Jerry Garchik. I'm a civil rights lawyer, and I wanted to ask Mr. Zimmer, should we worry about the electronic watermark that's going to appear? I think that's a DRM technique, but can it be used to track ultimate users?
Are these on? Yeah. I think in general, yes. Unfortunately, I haven't studied that particular. I don't know if maybe my other panelists know more precisely about what this watermark is going to entail. But any ability, if that's something that's going to carry with me, if I'm capable of downloading a page or something like that, that's the same kind of problem we have with RFIDs in library books themselves. To try to be able to link me to a particular page of a particular book, that would be something that would draw my concern. I just don't know as much specifically about what that provision might be.
Yeah, well, let me, if I could just jump in on that too. I mean, so part of the problem here, and I'm sympathetic to this to some degree when talking to Google, is that the design of the product is in various stages and things. And so there's always this way in which, you know, and somewhat legitimately, Google can say, well, we don't know yet, right? We don't know what it's going to look like in practice. And so in some ways, though, that makes it even more important that the commitments early on for how they're going to handle information from whatever source, whether it be Watermarks or others, is important, and then what the enforceability of those promises are, right? So one important point to contrast privacy policies with the class action settlement is that if the settlement is approved, Google is bound and would potentially be in contempt of court or subject to, you know, additional remedies if they violate the settlement, right? So building things and baking them into that settlement pose a certain kind of remedy in case there are violations in whatever technological implementation happens. Versus privacy policies, which can change, there's some question of how enforceable they are and by whom, whether individual people could enforce them or not. In fact, you know, any of you who've been following this sort of case around the accusation of someone being a skank, and it was an anonymous blogger, and then that identity was revealed, the anonymous blogger's identity revealed is threatening to sue Google, saying that her privacy was violated. I mean, there are some open questions, and so you really have to, I think, also extrapolate out from any particular technological concern you have to how, in general, if Google changes a product, they won't be able to change their commitment to privacy.
And if I could ask Angela and Tom to comment on this as well, do you have experiences where you're lending electronic materials? And when you, let's say, lend an e-book, is it in any way digitally linked to the patron? So if I go to my, I think the San Francisco Public Library, for instance, will let you borrow an e-book. Mm-hmm. If I download that, is it, you know, Chris Hoofnagle's version of this book? Or do you know how that's executed?
Tom may be able to speak more to some specifics. Is that true? Or
Well,
no?
we had a huddle right before this panel began, and we have licensing requirements that strongly discourage anything like that. And the person responsible for collections at the Berkeley Libraries, who's in this room, couldn't easily think of an avenue where that identity could be snatched.
Okay. It's, I mean, I think it's generally a concern, and one thing that we need to think about is that libraries work with lots of different vendors. Libraries incorporate the products and services from a number of different companies. Google obviously is unique in terms of the size and scope of the resource, and I think you know, we get into some of the questions about competitive pressure that Michael brought up being built in, right? You know, in terms of some other products, some of the ebooks and other electronic resources that libraries use, I think there's a great deal of competitive pressure and libraries, as I know Dan knows, and I think he even commented at the ALA conference this summer, librarians are really tough negotiators when it comes to our core values. When something touches on a principle like privacy, like intellectual freedom, we're really tough negotiators, but we need to think about the unique situation with Google and the invaluable resource that Google Book Search presents in the form of the institutional subscription database, the public access terminal, that sort of thing.
So just to observe, there are core values and then there's core experience. Libraries have had a lot of experience in keeping the records of people who use special collections. Mm-hmm. And I'm honestly unaware of a chilling effect over all these decades. Presumably we could pull out everybody who's used the Mark Twain papers over decades. Mm-hmm. I'm unaware of anybody who would hesitate to use the papers because, you know, they're leaving footprints. So this is relevant to the corpus debate. If you have the corpus in enlightened administration by research libraries such as ourselves, it's hard for me to imagine that an investigator would feel chilled by filling out a research protocol and, you know, in effect being registered with the corpus. And I think that's the way the university librarians who worked on the Google Book settlement sort of took the corpus discussion when we heard about it.
And in a way, it's kind of like a human subjects clearance, kind of a price of doing business. with that material. We have another question over here. Cindy, do you have a microphone? Okay.
Yeah, I do. Hi, I'm Cindy Cohen with the Electronic Frontier Foundation. We were the proud clients of Jason and the Samuelson Clinic in drafting a brief around privacy that'll, on behalf of about 25 or so authors. And one of the things that came up, I thought, that was really interesting, and Jason touched on it a little bit, is this question of what paradigm we're going to have. And I've been thinking about it a lot in the context of, what level of commitment do we want Google to make on some of the privacy things that they've been telling us in private, and some of the things that were alluded to in their public FAQ. And I suspect before we get to October 7th, we'll see more from Google about what they want to do around privacy as well. And I've been thinking a bit about what paradigm we think we should hold them to in terms of the enforceability of their commitments, and whether the paradigm of a one-sided privacy policy that is enforceable, maybe not at all, or maybe just by a government agency, versus a real commitment that would give standing and the ability of people affected to really take a stand for their privacy in the event that Google takes a wrong turn. What is it that we want to think about in terms of the paradigm for kind of holding this Google, holding Google accountable for the promises that they make? Because I think that the paradigm that we have on the internet now in general is really not a particularly enforceable paradigm. And so given, I think, Jason's point about, well, this is different, they've got to get approval, I've been thinking a lot about how we would make these kinds of commitments more enforceable, and I wondered if the panel had some thoughts as well.
I mean, one challenge that I see I think paradigm is the right way to look at it, and I sort of set it up in my talk as you have the library way of doing things and you have the Google web way of doing things, but unfortunately it's not quite that simple. And I've sat down, Tom earlier was talking about what if libraries want to offer personalization services just like Amazon does. And I've sat down with the digital services people at New York Public. They want to do exactly that. You borrowed this book. Look, everyone else that borrowed this book also looked at these. Maybe that would help you out. But they're torn. They're librarians. They're saying we can't collect. We need to start collecting data if we're going to track this long tail. So you sit in a room full of librarians, and half of them love the idea, and half of them hate the idea, and will quit if you do it. So we are sort of doing this kind of paradigm shift moment where do we need to create this sort of this middle ground where our library is now going to be forced to start thinking in a little bit different terms. Do we need to loosen up on some of these core values in order to become more relevant or more competitive, if you want to use that kind of term, in this digital world? And that's a challenge that I draw out sort of the stark differences, but I think we are going to need to sort of find this middle area. How to do it, unfortunately, I don't have the answer to, but maybe the librarians here do.
Well, I think that's a fascinating issue right now, and where we're headed. When I go to the Chicago Public Library, which I adore, if I go to them and say, I checked out this book 6 months ago and I never finished it and I can't remember what it was called, can you help me look it up? No. No, we can't. And that no answer is that's a spark that says, wait, what, are we doing the right thing here? In some ways, I would love to have recommendations about what other people who read the books I read are also reading. In another way, I think, in addition to some of the concerns Michael raised, I wonder what that implies if we think about going that route, and as we're considering that, what does that imply for the direction of scholarship? When we're thinking about research, if people are being directed toward more like this, does that have an impact on the direction of research and scholarship in this country? Are we becoming compartmentalized? Are we following the obvious paths that are presented to us through some of these algorithms, as opposed to some other really interesting creative processes? So I wanted to bring that up too.
If I could, I just wanted to ask and add one quick thing. So one of the issues too, again, this goes to the sort of future predictability, is around this trust question, and that people have raised about trusting or believing, right? And part of that is because we have real people from Google that we've been able to talk to, or we have real experience with Google, but that can change over time, right? Lots of people leave, lots of people go. I mean, different companies, have represented, been represented by people over different times with different philosophies about privacy, wiretapping, for instance, things like that. And so one of the things I want to say is if you look at the Google privacy policy, they have a heading called enforcement. But if you read what it says there, it says you can contact us with questions or concerns, and we will respond to those questions and concerns. That's the enforcement clause. So as a lawyer, I look at that and I say, well, I mean, if they respond honestly, that's great. And if they deal with it, that's great. But what if they don't? What are my options? I'm always thinking about clients. What are your options? Who can I sue? Can I go and arbitrate somewhere? Can I get a government agency involved? How easy is that to do? I think there's some serious problems with if that doesn't happen. And so that's where the other concern, that's the sort of worst case scenario concern is, what happens if they start doing everything we don't like? And one of the issues is right now with the settlement, because of this broad access that they need, the permissions they need from basically hundreds, millions, if not more people, it gives us an opportunity to get them to commit in legal language in a binding document that would be different than all the other products that are sort of ad hoc where you can sign up or not, right? So now is an opportunity to get that commitment that could be enforceable in a way that is not, come talk to us and we might address your concern. And I will say that Google has been very good about addressing many of the concerns, but again, it's not binding in the way that it would be if it were in a legal document or a contract.
And we haven't reached one issue that I think is really important to this discussion, and that is what do the panelists think the legal standard should be for criminal or civil access to patron records of the GBS corpus? Has anyone articulated a standard that would satisfy the civil liberties community? And is it fair to impose that upon Google?
I can certainly speak to that, but I don't know if I've been speaking too much.
You're the lawyer.
Okay, well, so, I mean, in the cases referred to, right, about government requests, there have been a couple of court rulings. So Tattered Cover, which is the Colorado bookstore, was about the cops had actually found people running a meth lab, and they found some evidence that the books had been bought from Tattered Cover, and it was the Anarchist Cookbook. I mean, like, these are really bad facts. These are really bad people, right? And you have the Kramer Books case also, which is about Ken Starr going after Monica Lewinsky's kind of reading list. You have these other sort of situations that vary. And in these cases, what happened is that the bookstores took it to court, they committed to taking it to court, and then a judge looked and scrutinized what the government had, and then in a sort of transparent, accountable process said, no, you don't get this information. And Angela's talked about this too. And that is a good process. And so I think that if it were up to me, I would ask that Google commit to always challenging requests at that level, demanding that they go to court to get a warrant or having a judge review the request. Because here's the thing. So the standard is, under all the doctrines, that you need to show that there's no other way to get the information. It has to be a compelling need to get the information. Judges look at that. If there's a compelling need, the judge will order Google to turn it over, and then Google has to turn it over, right? So if it's a situation like an emergency or some kind of criminal situation where there's life on the line, a judge at the middle of the night is going to grant that order. I mean, it's going to happen, right? But the point is, if Google doesn't challenge it, there's no accountability, no transparency, and no review, and we have to trust their good faith belief that this is a good thing to do, and there's no way to know how they're making that determination.
That is a high bar, and I see Dan has a microphone and probably wants to respond to that.
And I want to. This is an area, and I play a lawyer quite frequently. I will say this in terms of the privacy, and in this particular issue, I am very cautious of playing a lawyer because there are very, very subtle nuances here that I know even I struggle to grapple. What I wanted to point to, and I'm going to go to what Michael said, something that I have learned a lot through this process, and I'll use your Street View example. One of the challenges with Street View is often products, they aren't out there until they're out there. So the public discussion of privacy about a product, especially with Google, other companies are more public, doesn't happen until the product is already there. And in this case, we actually had this product that was effectively pre-announced. Okay, and I will say that if we had put privacy in the settlement, it would have been woefully wrong. Okay, that's the one thing I know, because the amount that we've gained from the discussions with Jason, with Cindy, with CDT, with ALA, I know I've learned a lot, and in fact, it does affect the design. So in fact, having these discussions as you're doing the engineering design, which we're doing, and in fact, part of the responses we provided to them is, for some of the things, we haven't done the engineering part of the engineering design. And so we're still trying to figure out certain things. But my level of understanding of the requirements is grown by a factor of 5 because we've engaged in this discussion. And as we think about this, I think we all realize that the future of reading is going to be books that are in print today and books that are printed in the future. I mean, the bulk of it. I mean, I think there's huge value in this. But as we talk about consuming electronic content, it's not just about Google. It's about Amazon. It's about Barnes & Noble. It's about 20 other providers. And in fact, we're seeing a transformation from libraries as a source to commercial entities as a source of accessing, and that we're accessing information digitally. Okay? And part of what I'd encourage, okay, is I know I've learned a lot in this discussion, and I think the real dialogue, and we haven't gotten into many of the details. I know if I had to list the top 5 things I've learned, probably none of them have come up in this panel in terms of the issues and the discussions and the, oh yeah, good point. How do you delete, one example, how do you delete a book that you bought? Right? In other words, you buy a book, then you don't want, once you get married, your wife to go look at your account and to know what you read before. You can throw a book away. How do you throw something away from the cloud? It's something that I hadn't thought of as a functionality. I think it's an important functionality, and we're thinking, how can you make sure that someone can delete a book? That's just one of many. And one thing I'd encourage, I actually think that this question of privacy in a digital age as we consume digital books, be it from a library or be it from a consumer, and then what are the standards? Because certain laws have been enacted for protections when libraries were the source of getting information. Okay? It's not just about commitments from Google, it's also about what type of legal change we need to extend some of the protections that libraries have to other entities too. So I think the big issue with privacy, and I understand the desire for a strong commitment, here, I think what it's done is put a spotlight on this complex and challenging issue that hopefully, I think, independent of the Google Book settlement, I think it's a form of itself as a full-day discussion of going through all the nuances, and some of it is about legal change, some of it is about policy, some of it is about libraries when they license, some of it is about consumer access, and we've really only scratched the surface of what is a very complex issue.
Okay. Yes, ma'am.
Hi, my name is Eli Edwards, and I have a question that somewhat harkens back to the Google Street View example that was brought up by Professor Zimmer. Of course, Europe has very different privacy policies than the U.S. The U.S. doesn't really have a privacy policy, but with the change in the administration, there's indications that the Justice Department is more interested in user privacy. The FTC is much more interested in enforcing information privacy over the web. The FCC is even starting to look into this area. So I'm asking, even though none of you are policy people, if you could put on your policy hats and tell us whether or not you think there's a legislative or administrative role for the government in the privacy issues over this settlement and over this product.
But a short answer actually is following up to just what Dan was saying, that I think since we have such a scattered approach to privacy legislation in the country, it's difficult to bring it all together, but since we have privacy laws that address library privacies, do we need to rethink those and expand those to any kind of intellectual information seeking activity that I have? And that's where I think it should be anytime I search Google or pull up something on my iPhone or whatnot. If I'm engaging in some kind of intellectual information seeking, that should be protected in the way that it already is protected if I happen to be doing it inside the walls of a library. So I do think we need to think through that. It's the complexity that Dan was just talking to that I think we all recognize, because now we have like the combination of convergence and explosion of how we do all these kind of things. And it's no longer just the library or just the video rental store that it was easy to compartmentalize when those laws were written decades ago, and much harder for us to do now. Are we going to get a large-scale privacy legislation? I can toss that to you to see if you think if that's feasible or not.
Actually, I mean, Chris, you've had some experience with privacy policy making.
We're going to have, I think we'll see some action on behavioral targeting.
Targeting,
But will that be specific to this type of relationship? I'm not sure. We just have a few minutes left. Tara Wheatland had her hand pass. Yes, Hal Varian.
So I'm Hal Varian. I work at Google, but I'm not involved with the Google library program, so don't ask me any questions about it, because I don't know the answers. But I do just have a question for the audience on this issue of library access. So as I understand it, the computers that you would use to access Google would have a fixed IP address. They would typically, you would delete cookies between every session, as you do at all library computers. And there's no sign-in necessary to access the material. So how would anybody ever trace use? The IP address, there's hundreds of users at any given library who would use...
You should go ahead and...
Well, yes, the library would have to keep track of who used it, exactly.
No, well, and the other thing is you're not required to log into your Google account, but many people do. And so there is this question of if you were checking your Gmail, and you then start to use book search, would there be a record created?
So the thing that's curious about that I understand is, of course, you have many Gmail accounts or many Google accounts. You could access it under any
But in reality, how many people are going to be sitting there at the terminal checking their Gmail, and then they say they need to look for a book and they want to read it? Right?
It's the technologically unsavvy people that I think we're often concerned
about.
I mean, this is the basis of consumer protection.
Right. So you could prevent that from happening if you wanted to, for example.
Well, Google could prevent it.
Yeah. Well, people could prevent.
And how to be clear on that, we aren't logging your. I mean, we've been pretty clear about what goes with the Google account. So if you happen to log into your Gmail at the terminal and then you're using it, we're not logging that by your Google account.
Correct. So the thing is, it's something where the library use in general, seems to me, can't be tracked inherently unless the library specifically tries to track it.
So, and just how, I mean, that's true in the library. This is going where I'm going, where there's complexity. Right. More and more people don't go to the physical library. Right. So the obvious answer there is, so yes, everybody can go to the physical library. The world we're going to in the future is this blended world where people are sitting in a networked environment and connected, and that's where the challenges become very helpful.
And I think that's where the really interesting issues are, but I think the issues that we started out talking about in the narrow library case, it's not much of an issue unless somebody really goes out of their way to track usage, because Google can't track it.
Question over here.
I work for the Berkeley Public Library, and it's my understanding that it would be at one semester.
That's, and we can get,
This is being recorded, so please ask your question again.
My question is, would the access to Google Books be through one computer, designated computer only at a library? That was my understanding.
Public access service.
you know what, I think that is going to come up in the afternoon with Pam's panel, so why don't we wait, since everyone will be here and the self-privacy, we'll talk about that in the afternoon.
Well, I think if you're asking for, one traceable IP address versus the library's, firewalled IP address that they use all their resources from, that right there is a concern for me. Why does Google want to have a separate IP address versus, if that's what I'm... No, okay.
That's I mean, Chris, let me ask you. I mean, I can answer that now, but that's its own 4-minute discussion about the subscription versus the terminal versus.
And we only have a couple minutes left.
Sort of
we still have a few more questions.
Let's bring it. It'll come up in the afternoon panel, I'm sure.
Hi, I'm Liza Boyd. I'm a journalist with Media Bistro. And I thought it was really interesting how most of you all, if not all of you all, said that you were really excited about the Google Books project and you hoped that it would come to fruition, but you had these concerns about privacy and you'd really like to see more firm commitments. So I'm going to throw a hypothetical at you, which is if, let's say, October 7th is the deadline for deciding, Google has not made any more commitments than it's already made today, and you're king of the world, and you can accept the settlement or reject the settlement. What would you do?
I don't answer hypotheticals in acceptable response.
It should be pointed out, many people know this, that the so-called HATI-Trust, which is a university-run consortium, is fully capable of serving up certainly the public domain digital copies we've gotten through the Google process, and it reaches farther than that. So we actually do have an alternative way to get to this content. Still not answering your question, but I just wanted you to know that.
I'm not king of the world, and I'm here on this panel as a representative of the American Library Association, and in that capacity I can tell you that the American Library Association, the Association of Research Libraries, and the Association of College and Research Libraries have come forward and said, we support this settlement, even without privacy protections, and our strong recommendation is that the court exercise vigorous oversight over the settlement. I'm going to leave it at that because I'm here in my official capacity as a representative of ALA. So that's where those library associations stand on behalf of our membership.
So I should say two things. One is that because of things such as an attorney-client relationship, I probably can't speak to it fully. But I will say if I were king of the world, then I would say what I think is reality, which is it's not an all or nothing. It's not an up and down, actually. And I mean, even though that is the technical formalism that will be applied from the judge, he will have to do this particular thing. The reality is, in talking to all the class action lawyers I know, and I'm not one, but I've sort of gathered a lot of intel, is that these things get changed all the time. They get modified, right? I mean, typically it's in the context of the lawyers asking for too much money. That's actually what it is. It's like the class members get these little coupons for, $5 off your next hard drive or whatever it is, right? And the lawyers take $45 million to the bank, right? And so, that is an up and down vote. But what the judge will say is, I'm not really comfortable with how much money is going to the lawyers here. I'm uncomfortable with this, so I'm going to reject it. And I want a different settlement, one that's not so disproportionate. And lo and behold, with the incentives in the system, there's another settlement that will come forward fairly quickly that has different numbers, and the judge may approve that, right? So if I'm king of the world, I say I want a different settlement, which I know is fighting the hypo. My students do it to me all the time, but I'm going to take that advantage here.
Yeah, and I share Jason's sentiments there, and I think if I was king of the world in that scenario, I would try to find a little bit different way of sort of framing what the settlement is doing, and focusing more on the public interest side of things. So if we're going to end up needing to create some kind of the large registry and a large body to drive this, perhaps we can do it in a way where it's not a for-profit corporation that has a different set of standards and principles. No matter how great the people are there, it's a different beast than if we had it being a consortium of libraries on their own trying to do something like this. So is there a way for us to sort of rewrite history since I'm king of the world? So we come to the problem in a little bit different direction. I've also been asked, what would I do? What am I going to do as someone that has a claim in it? And that's a difficult thing for me to answer in a few seconds as well. But I probably would, if I was someone that had really strong concerns about intellectual privacy and freedom, I would seriously consider opting out on the basis of that.
And with that, we've exhausted our time. I'd like to thank the panelists.
Thank you.
Other people.
Exactly.